Good morning, and thanks for joining us here on Condo Solutions every Monday morning from 9 to 10 o'clock. We talk about things that affect you and your condo or your homeowners association, issues that you may be dealing with, that you may have questions about, and we're here to answer those questions. My name is Mark Breckbill. I'm a local CPA and a licensed community association manager. It's funny. Why everybody says licensed community association manager, and I don't know why they say that, because why would anybody want to be an unlicensed community association manager? Huh, Peter? That's. I guess there's no need to say that. That's what the CAMs always say. There's no need to say the license part. Anyway, I'm here to help with some of your issues, but the big person that is the person that you all listen for is Peter Mullengarden. Peter's on the line here, and he's our attorney. Been dealing with homeowners associations and condos for a gazillion years, and in fact, there was there was all of the various ages, and then there was the Mullengard age, where he started with the condos and homeowners associations. He was the one that actually wrote the documents for the first cave that went condo. So Peter's been doing it a long, long time. And pretty soon here, they'll be able to call him an expert, because the bar is going to allow that now. If you've been doing it for over 200 years, you're allowed to call yourself an expert. Good morning, Peter.
Good morning, Mark.
Did I get that right this morning? I'm on the money. Hey, did you hear they said?
Well, you were the first violation, so.
That's true. I was.
So you were locked in the other cave for violating the first set of documents. Okay?
That's right. Yeah, I probably painted a flag on the outside of my cave. That got me into trouble, probably. But anyway, and we got your name finally in the promo. After 16 years, I guess we decided it was probably good to put your name on there. You weren't going anywhere, I guess. But so we got your name in the promo. Mine's first still, but we did get your name in the promo, so I want to mention it.
Okay, thank you.
All right, so we're here to answer your questions. 220-9788, 220-WSTU is the number in the studio, and we will gladly take your call. If you've got any question, feel free to ask it. We don't need your association name. In fact, prefer that we don't, because it might cause some other association to think it's not their problem, and it may be their exact problem, so they don't want to miss the answer. So we don't need the association name, and you can use any name you want to call in. Just give us one so we don't have to say, hey, you. And unless your name's you, and then we'll say you. But otherwise, we need to get just something to call you. And like we always say, we'll try to give you the best possible answer that we can based on our understanding of your problem and your explanation of what your documents say and what you have as an issue. But again, we don't have your documents, so as many of you know, we can't give you a hard and fast answer if we haven't seen the documents, because documents can override the law, and we can give you an answer based on the statute or some rules and regulations that have been issued, or court cases even, but it is very hard for us to give you an answer that is based on your documents if we haven't seen them. You certainly can. We certainly welcome your interpretation of those documents, but as again most of you know, it's very difficult because those documents aren't always the clearest in the world, and sometimes they may even be conflicting internally. So we'll do the best we possibly can, but we give you what we call a radio answer, which means we base it on what we have as information to us. And we also will tend to talk a little bit around, or we'll expand the issue maybe, or expand the answer to kind of hit some of those people who don't have the exact same issue as you, but maybe very close. So first caller this morning is Jim. Go ahead, Jim.
Good morning, both.
Good morning.
I have a question. Our association is an old one here in Stewart. We have just redone our documents. And one question that I have that hasn't come up yet here is we have in our documents a 1-year waiting requirement after you buy the unit before you can rent it. And the question is, if somebody sells their unit that has a renter there already, and they sell it before the agreement with the renter is up, and they don't have any exculpatory language in that agreement with regard to the renter, does the association have to recognize that lease even though it carries over into the next owner? And if yes, can we then make the next owner, after that lease expires, wait the required year?
Yes. Go ahead, Peter. You can expand on that if you want, but that's one I've had to deal with, and
basically
the answer is yes and yes.
Yeah, basically, I mean, the way I've read a case or two is, the lease is not cut off, but then the year will start at the end of that lease for the next owner.
So here's what happens, Jim, and I've had this situation is, legally a tenant has rights. So once the owner of a unit signs a lease, it binds that person person and anybody who subsequently owns the unit to that lease. Now, if that lease is in excess of a year, you may have the ability to do something there, and you may also have the ability to do something if it has a renewal privilege in it. You may be able to stop the renewal, but if they already have a signed lease and it's let's say they signed it 2 months before or a month before, and then sell the unit, well then that lease still is valid, but when the lease is over, the association can require that the unit sit vacant or be owner occupied for a year before such time as it can be leased. Typically, if you let's say you keep your unit and they pass the law that you guys pass the regs that you have to live in the unit for a year before you can lease it. If you're already there and an owner prior to that time, typically, especially if you objected to the no lease provision for a year, you're grandfathered in, so you will be able to still continue to lease your unit, and but when you sell it, the unit is not grandfathered in. So if I sell my unit, I'm in there 4 years after the provision changes, and now I sell my unit, the person that buys it isn't going to be able to lease it out for a year.
Well, our documents do and always have had a 1-year max and a renewal requirement. So what you have said fits perfectly with our documents and answers my question. So this hasn't come up yet, but as with anything condominium-wise, it's bound to while I'm on the board. So I thought I'd get the expert advice ahead of time.
Yeah, it's a good question, because a lot of associations have started entering into these restrictions, and they've put these leasing restrictions on it, and going forward, there's going to be people that are going to try to deal with these things and change them. One thing I would say, Jim, and this is just for our audience too, and Peter, jump in on this, but you may need to take a look at what other provisions are within your documents. They may be, it sounds like yours maybe have already been addressed, Jim, but a lot of times when these kind of provisions go into play, you need to see what the requirements are on guests, how long guests can stay, what has to happen, and how guests are going to be monitored, because you'll find all of a sudden that guests are coming for 3 months at a time. And so you need to find out what the restrictions are on guests. What is a guest? What are they going to prove? What kind of documentation do they prove that it's a guest and not a tenant? Because people play a lot of games in that scenario, because they know that it takes you a couple months to deal with the issue. It may take you a month to find it, a month to deal with it, and then in the next month they're moving out. So if you take legal action, basically courts say it's moot point.
We have been through those various things, and we do have in our rules and regulations our provisions for that. And also we've amended our declaration and bylaws to fit those kinds of things. We actually go through a very careful interview process here, where the applicant, whether it be a new buyer or a tenant, has to provide a lot of information, and we go through that with them during the interview process the rules. And you're right, as far we have a provision in our documents, have always been there, and still is, that you can have guests up to 30 days. And you're right, all of a sudden people started having a while ago guests. We have now put in our rules and regulations a requirement that anyone staying after, i.e. an extended guest, like a family member, that they go through the interview process too. And during that process, we check their background. We do a background check with their consent. So your advice is good, and we have been down that road already. And as I said, the only thing we haven't encountered was the initial question that I asked. But if there's nobody waiting in line, I have a follow-up question that relates to that interview process.
Sure, go ahead.
Our president has suggested to the board, and we haven't voted on it as a policy decision, but we're thinking about it, adding to the questions that we asked during the interview process, getting a credit score. And is there any legal prohibition to getting a credit score, again, with the consent of the person signing the paperwork who is being interviewed? And we on the board, including the president, are weighing the pros and cons of doing this as far as tenants go, renters.
Well, let me jump in there, Jim, and ask you a couple things. Then Peter could get in on this one. But what are you going to do with the credit score? Because I mean, I know what you know. The thought is, let's say they had come in and they got a credit score of 520. So are you going to deny them? But see, you're not a party to the payment of the. It's the landlord that's got the issues, and so it might be Section 8 housing, and if it's Section 8 housing, you know, you may not be able to. You know, it's interesting, and Peter, I'll get your opinion on this, but I was told by an attorney recently that you know, typically associations are doing background checks, and they do criminal background checks. And it used to be if you were a felon, you couldn't you couldn't lease. You know, they would deny you if you were a felon. But the attorney who deals with these situations quite a bit told me that 77% of all felons are African American, and so as a result, you're discriminating based on race. And so,
well, that's because HUD came out with a position statement a couple of years ago that to have a blanket "we don't allow felons" has a disparate impact on minorities.
right.
So therefore, you must go beyond just is it a felon? What type of felony was it? What has been the person's history since then? When did it occur? Have they been a model citizen since that point? You're supposed to take into more factors than just the fact were they a felon, because of this disparate impact upon minorities.
Yep.
That's an interesting observation. At the suggestion of our association attorney, she fleshed out a series of reasons for turning down a applicant, whereas our original documents basically said we had that right, but it didn't say why. So in the drafts that we received and exchanged with the attorney, I questioned that, and she explained that even though we have that right, it's from a legal point of view, in today's world, it's better to have a laundry list of reasons, and they're pretty thorough. And of course, I think we do that to defend ourselves against the owner rather than the applicant for rental, so that the owner can't accuse us of acting arbitrarily. But with getting back to the main point of the credit score, those are the very issues that we on the board are thinking about, and you've hit on them. And the person proposing that is also ruminating on whether or not he wishes to continue to propose that. It has not come up for a vote.
Well, Jim, here's where I would use that. You have the association has the ability to set a reasonable security deposit for damage to association property. And as soon as you do that, there's where you could, I think, there's where you could tie in legitimately the credit score. You could potentially waive that credit score, waive that deposit if the credit score was above a certain amount. Because of the fact that, the person's got good credit, so if there was an issue, you could go get, you could get the money from them. In other words, you'd be willing to allow them to owe you the deposit. I'm not saying it's good practice necessarily, but I'm saying that there would be a way to do that. But other than that, it's pretty difficult to use that. You could ask for it probably. It's probably not illegal to ask for it. But then the question becomes, well, now that I've got it, what do I do with it? And,
well, that was my main reason for asking you, because that's also my question, and it's also the person's question who, what are we going to do with it once we get it? I think his thinking initially was that would determine the kind of tenant that we would be allowing to live in here. But I think that it might be argued by the landlord, the owner of the unit, that that's his responsibility to make sure he rents to somebody who is not going to leave him hanging. I don't think we want to get involved in enforcing his rental agreement. We have a pretty strict rule that the board now has finally begun to realize it has to follow, that if you can only rent between 3 months and 1 year, and you can't rent more than once during that year. So that breaks it down to year-round rentals versus seasonal rentals. That's the kind of rentals we have in here. Mm-hmm. And after an initial flurry of discussion on the board and some split votes, I think our association attorney has convinced some of the board members that they can't do anything just because they're board members. I.e., I guess what I'm saying is we've calmed down a bit, and we're much more act the same with regard to all of these kinds of requests, which is what prompted my initial question in the first place about the renter who is left when the unit owner sells the unit.
Jim, the interesting thing is that from a landlord standpoint myself, I if I was an association, I like the 3 month minimum, because at that point you avoid the people that sometimes people that are in there for very, very short periods of time. They treat it like a hotel, and they don't really care. They don't really care much what they're doing. They don't treat it like some place that somebody lives. When you're in there for 3 months, a lot of the 3 month residents are seasonal, and they treat it as their home, and they come back every year. The other thing that, and I've said this before, is that I'm not so sure that landlords are a bad thing, but there are bad landlords. And I will tell you that if you have a long-term lease, longer than a year, that means a couple things. One, that landlord is serious about getting good tenants and is holding that as an investment long-term. So they're probably a good landlord. They want to make sure that the unit stays good. They're looking for the appreciation. They're not looking for the short-term flip or gain. And so to some degree you get, and they're going to do a better job on a long-term lease. They're probably going to do a little better job of screening that person, because they want to make sure that if they're going to have that unit tied up for extended period of time, that they have it, that they have a good tenant. I go back to the situation that, and I think we're seeing more of this, Jim. It used to be that tenants were considered to be transient, and frankly, if you're in a 1 year lease, you probably potentially are transient. But nowadays, we have more and more people who are in units and intend to rent for the rest of their lives. They may have owned a home up north. They don't really want that responsibility, and they don't want to deal with it. They don't want to have the ownership interest. They need that money maybe to supplement what they're doing. So they've sold the home up north, and they're renting here, and they're just renting long term. And I know my parents did that. My mom and dad moved down here and rented in Port St. Lucie for probably 15 years. So it was in the same place. They were in the same unit for 15 years. So at that point, that's why I say there's a couple different things here, and how you're going to use it. I think makes a difference on some of this stuff with the credit scores. I do think you can justify the credit scores if you have a provision in your documents that says that the tenant must make their payment to the association if the landlord is if the landlord, is or the unit owner goes into default on their unit or doesn't make their assessments, their payments. At that point, now you probably may have a legitimate reason to turn them down if their credit score is low.
Well, let me interrupt you right there because that's a point I hadn't thought of. But you're right, and we have incorporated into our rules and regulations the statutory provision on fines. We have a Board of Appeals, we call it the Fair Hearing Board, and we've kind of walked through that now for several years and got it in place. And we have the three-step process that our attorney outlined for us, warning letter and et cetera, et cetera. So we do have that, and we primarily use, in fact, exclusively use the acceleration method of collecting from unit owners who are deficient in their payments, and we've gotten that down to pretty much that they realize now that they don't want to pay a whole year in advance and pay attorney's fees. So all we have to do is send the warning letter, and we usually takes care of it. So we have embraced that statute in the rules and regs, and most of our rules and regs are assigned a B, or C type of fine, which is defined in them, and that works very well. As far as using that other tool, we're aware of it. We've never had to use it, and I don't think we would in lieu of the acceleration because that works so much more efficiently, and the lawyer is able to handle it and get paid for handling it, and we don't have to handle it in the house.
Yeah, that may be, but it's still hard to get a person out of a unit sometimes, and then the market's a little better right now, but it is also hard to move somebody. So if you can get anybody you can get paying the assessments, I think is a good thing, and that's why. And there are some issues, Jim, relative to the association's right to lease and things like that. But I would, those are reasons I could see using credit score. I will tell you this: being an ex-banker and knowing how really ridiculous a credit score is. I can move my credit score 50 to 75 points in less than 3 weeks if I know what I'm doing. So what good is that? I mean, it's a lot of it is, and here's the other side of it. Your best tenant may be the person that is got a lousy credit score because they went through a foreclosure and then a bankruptcy because of this recent economy, and they don't have the money. But they may now have a decent job. The economy's picked up, and their credit score is going to be horrible for a period of time, basically because they tried to pay. Sometimes your credit score is really bad because you made an effort to actually pay. You would have been better off filing bankruptcy and getting out and starting over again, and your credit score in a couple of years is back up again. Whereas if you try to pay and you just stay behind, but you just don't get any further behind, your credit score is trashed for a lifetime practically. So I don't put much stock in credit scores, to tell you the truth. I don't. To me, the thing that the associations don't do enough of is check references.
That we're very thorough on.
I think that's you can get and there's there's a limited amount of stuff that people can say, but when it comes to housing, most of the people you're checking with aren't smart enough to know, like me, what you can and can't say. And so they'll tell you if they had a good tenant or a bad tenant. Or they may just inadvertently tell you that they had, something that happened that may not work for your association. That no, they were good. Their kids, kept their bikes on the sidewalk and all of those kind of things. Well, that may not work for you guys, So
I think you've helped me convince myself in terms of my feelings on that thought, and I'm going to have a private discussion with the board member who's suggesting it, and I think he's probably will appreciate the comments. If there's nobody waiting and realizing you might have listeners that are interested in these kind of things, I'd like to tell you of the way we did handle one foreclosure.
Okay.
And stop me if you have somebody waiting, and I'll sign off. But we foreclosed on one unit. The person that died there had a reverse mortgage, and we learned very quickly how the banks go with their quickness, if you want to say that, in releasing the property or allowing it to be purchased. So we decided, and the same board member actually who was talking about the credit score came up with the idea, and it has worked very well. We decided for the first and only time, since we owned the unit now, to rent it. And we started off with about a $7,000 or $8,000 bad debt, and we found we amended our documents as well first to allow us to be exempt as an association to do this kind of thing, an at-will or month-by-month lease, which is not allowed in our documents except now for the association in this kind of case. And it has turned out most successfully. We found a tenant who, as you say, is very happy to rent and is willing to accept a tenant at will or a month-to-month rental, which is what we now have. And we have gotten that debt down successfully by several $1,000s each year, each month. When we go through our receivables, we look at each other and we say, boy, we hope this continues. So if there's anybody listening out there on another condo board where you're sitting on a foreclosed unit that you own, we've had great experience in renting it, but we were lucky in finding a tenant who would accept the conditions.
Yeah, and the other thing, there's two things on that I would say is, one, the other thing is that makes a big difference is whether or not the association is going to have to put any money in the unit to be able to lease it back out. Sometimes in the old days, back in 2007 and 2008, you'd go into these units and it looked like a bomb had gone off in there. I mean, every bit of copper was stripped out of the wall. All of the appliances were gone. It was a mess. And so then, you'd have to spend $3,000 or $4,000 or $5,000 just getting it in shape to be able to lease it. And that made it more difficult for some of the boards to make a decision, because at that point, if that unit sold out of there pretty quickly, then you weren't going to get your money back. But it is good because the other thing that happens there is when units are empty like that, they tend to deteriorate quickly. Things happen. You can have more damage. You can have air conditioners go bad, and now all of a sudden you got mold issues, and you've got all of these kind of things that can happen. So having somebody in the unit, I think, is a lot better a lot of times too. The other thing I wanted to mention is that you mentioned a reverse mortgage, and I didn't remember if you said, was it a reverse mortgage that triggered the foreclosure because the person died, or was it was the foreclosure because they weren't paying their assessments?
The foreclosure was because they weren't paying their assessment.
Okay. It's interesting because a lot of people don't realize this, but typically, a lot of times on a reverse mortgage, the banks will foreclose on that. Will go through a mortgage foreclosure when the person dies. Because here's the thing about a reverse mortgage as opposed to a regular mortgage is that with a reverse mortgage, there's a mortgage, and it's the same mortgage that there would be with a regular mortgage, but there's no note. So what happens is it doesn't affect your credit. So when the person dies, they go through the foreclosure process instead of the estate process, because the foreclosure process, when there's nobody living in the unit, is a lot easier. And so that's something that you'd be aware of. There'd be a little difference there if the person died. The bank may go through a foreclosure process on that, where even though even because they can take possession faster than to go through the estate. So I just mentioned that to people because a lot of people don't realize on a reverse mortgage, either from an association standpoint or otherwise, they say, oh, the unit's going through foreclosure. Yeah, it's going through foreclosure, but it's not the same foreclosure as a foreclosure on a regular mortgage because there's a note back there and the people owe money. On a reverse mortgage, there's no note. You don't owe anything. You just walk away. So
Well,
anyway,
that's very interesting. I appreciate that deepening of my limited knowledge. We were lucky, and it worked out well for us. We debated doing that for the very same reason that you initially stated, the initial cost. Fortunately, the unit had a long-time person living in it, and there were other family members who did not keep up the payments.
yeah.
And that's how it basically slipped into foreclosure. But there was no real damage. We have in-house staff, and we painted it and made it presentable. And so we didn't have that initial question of a huge investment and then, yes, possibly losing that investment if we sold it right off. It's worked out, for us, it's worked out very well. And I just wanted to share that for your listeners as well.
Okay, well, we appreciate that. That's good information for people to be aware of.
One final question, and I thank you for all your time. Peter, do you know yet if the legislature has done like it did last session and give us all these huge raft changes, or is this going to be an easy year to keep up to date?
Well, they have made several changes. It appears that the governor is going to, sign off on the bill. I'm not saying it's, zillion changes, but there are several that are coming, dealing with a variety of issues, dealing with the association's website requirements for if you have 150 or more units. They've clarified the term limits from the amendment last year. Did a few things to official records. So there are more things to be aware of.
It seems it took me a long time and in a couple of seminars, Treasure Coast seminars, to digest all the changes that were made last time and keep them in our book up to date. But it seems many years ago, I was a legislator in another state, many years ago, and it seems like condo laws seem to be changed whenever a particular legislator has a constituent down here who has a particular problem.
That is exactly correct.
And then they like the term limit issue a few years ago when we already were a 2-year term and we had to go through all those stages and get it approved again. Anyway, this greater definition, I'm not surprised. So I'll look for that.
Now they change, and you're right. They are quite reactionary, okay, to certain constituents.
Yes.
Coming out of the South this time. Well, it comes out of the South a lot of times, but out of our friends down in Miami-Dade. But before, last year they said you couldn't serve more than 4 consecutive 2-year terms, which was kind of odd because it was silent about 1-year terms. So they've changed that, I guess you can say corrected that, to say you can't serve more than 8 years in a row, period, whether it's a 2-year term or 1-year term or whatever. It's 8 consecutive years.
Do they still have in there, and when they were debating that, I was following that and wondering to myself if they'd be smart enough to put in a provision where it doesn't apply if nobody runs for an open seat.
Yeah, that's still, yes, that is still there, that if there are fewer candidates than vacancies, or the same number or fewer than the vacancies being filled, it is not applicable.
Well,
it's also not applicable if you receive 2/3 or more of the votes of the people voting, not of the whole place, but of the people voting. So it's like if you're elected by a landslide, then you're also exempted or not affected by the term limit provisions. So
I'll sign off by saying this. During most of my career, I was a municipal and county manager in another state, and was very much involved in municipal law and county law in that state, having been in the legislature before going into that field. And I got to tell you, when I retired and came down here and got as a board secretary, got into condo law, we're almost as confusing in that as municipal laws. It's amazing.
There's a lot of similarities. They're like little cities, right?
Yeah, that's
so,
right.
Yes.
So there are a lot of similarities in
little communistic communes.
Well, luckily we now have we used to self-manage, and now we have a very competent property manager, licensed Cam, and he's doing he's also learning. It's his first job, so we're doing very well now. But it's taken us about a decade to get there. Listen, I'll let you go, and I thank you for letting me take up all your time. As usual, you've been very helpful and very informative.
No problem, Jim.
Well,
Thanks
thank
for
you.
calling.
All right, bye now.
Bye. All right. Thanks, Jim. We appreciate that call. 220-9788, 220-WSTU is the number in the studio. If you have a question or about that issue or any other issue that you want to follow up on, we'll be glad to answer the questions. And Jim's questions were good ones because they're the kind that vary and gives us an opportunity to talk about different situations that can arise at various associations. So it's a good question. And any of the callers that want to ask a question, we still have time to get one more in, probably 220-9788, 220-WSTU. It's interesting, Peter, that I was looking at some of these things. It's funny, and it kind of goes with some of this stuff with foreclosures and other things. Is that one of the things that I didn't realize is I had gone recently with I did some Section 8 housing, right, and it worked out. It worked out actually pretty well. I mean, they had you get, as a landlord, you get paid on a regular basis. The tenant was good, and she had a couple kids that were with her, and she was good. It was a good school system. She was glad to be there. And I had some issues with the place relative to some some moisture issues, but one of the things I didn't realize, and it does make a difference, is looking at who your tenants are and what their particular issues might be. And in this particular situation, and I think this is true whether it was Section 8 or anything, if somebody's stretching a little bit to get in the unit, and she was, because she wanted to be in this neighborhood, you forget sometimes that they may have to cut back on some ancillary things that increase the association's liability or your personal liability as a landlord. For example, they may try to cut back on utilities because the utilities are high, so they don't run their AC as much as they should, which then you can have issues with moisture in the units, or they may have issues with if somebody's, for example, is in a situation where financially they can't afford it, they're in a foreclosure or whatever else, they may stop doing basic repairs inside the unit, which then causes a problem for a lot of things that can go wrong, and can require the association to have to deal with more things. The association has to be more vigilant if the unit's empty, because if something happens, a pipe breaks or whatever, next thing you know, you're dealing with an issue of water in the unit, plus it's in the walls, plus it's it's going all over the place, and at that point there may or may not be decent insurance in place. You don't know what's happened. Somebody may have a policy that's got a high deductible or whatever, and they may not be able to pay. So there's some of those kind of issues that we become more prevalent when you have to deal with if somebody's stretching, and I'm talking just in general. I mentioned my parents. My parents had to stretch a little bit to get in that unit when they moved down here, but then afterwards, because they were a good tenant, the landlord kept the rent the same, and so as a result, they were able to afford it, for all that time. In fact, at one point, I think my mom was actually asked if she wanted to be on the board of the association because she'd been there so long. But anyway, it's an interesting scenario when you start talking about what associations should and shouldn't do relative to tenants. And I'm a more of an advocate of of allowing a little more flexibility on some of this stuff, because I think down the road the ability to lease your unit is going to make a difference. I know, for example, there are some places over in Palm City that if or now that they have reduced the ability to lease the units, it has affected the value of the units, because some people were coming in there and they're buying them as investors, and the nice thing is they provide a floor for the value of the unit. In other words, if the price starts going down too far, they know that they can come in there, buy that unit, lease it out, and make a profit. And so it also provides, and people don't think about this, it also tends to provide a little bit of a cap. In other words, if we had this big real estate bubble that caused a whole lot of problems for everybody, and that bubble didn't occur as much on the commercial side as it did on the residential side. And the reason for that was that on the commercial side, when you appraise a commercial unit, you take into consideration its replacement cost, its comparable sales value, and its income value, what you can earn in income. And the lower of those numbers is going to be your appraised value generally. So even if on comps a commercial building is selling for $1 million, if on an income approach it's only justifying an $800,000 purchase price, you're going to have to put some extra cash down. On the residential side, we never got into that. So people who are flipping units and were buying because, oh, it looks so beautiful, or I got to get in now because it's going to be twice as much a year from now, or whatever the reason was, there was no income support for it. Frankly, the income value of a unit, of a home, does control it getting out of hand price-wise. And, if you're a seller, you might say, well, good for me, I get my money and I'm gone. But, frankly, if you're in there long term, and all of a sudden, none of us want this housing bubble that we had last time. Nobody wants in an association to have a situation where 15% of your units are vacant and nobody's paying any assessments. So I kind of have mixed emotions, because if you can lease in your association, it does, even though it's not used for appraisal, it does add as a governor up and down on the value of your homes. I like it because it tends to smooth out the price a little bit. Yeah, you're not going to get the big increases, people buying speculative, trying to flip it, because if they get stuck with it, they can't lease it out. But at the same time, it's not going to fall as far, because investors will come in and support the market, and not all investors are bad. In fact, I know a number of people who are real estate investors on the residential side, and they're very good investors, and they want their units to stay nice because they're counting on selling them and getting out of them and at some point and having made money. So, I have, like I said, I have kind of mixed emotions on this whole landlord issue and restricting leases and all of those kind of things. And to say, well, you can lease, you just got to hold a unit for a year, that takes out any leases from an investor standpoint. No investor is going to hold a unit empty for a year to be able to lease it out. They're just not going to do that. So it's just too expensive. So anyway, just throw that out there as for something to people to think about. I just think that you can monitor that situation and still allow leasing. And now that they've allowed associations to take deposits for common area, that kind of, if you've got a situation where you're concerned about that, I think you having a legitimate deposit is a good one, because what I found, and I think is going to happen, is that if I was the landlord and I'm getting let's say I'm getting 1 month's rent as a deposit, as a security deposit, well, if the association, and let's say that's $1,500, if the association's got $1,000 security deposit, I'm not going to charge them $2,500, because I can't get a tenant that's got first, last, and $2,500. So at that point, what I'm going to do is, of my $1,500, $1,000 of it, I'm going to have the association's going to be holding on to. Well, as a landlord, that makes me pay a little more attention because I don't have the security deposit that I used to have. So I'm going to take a better look at my tenants to make sure that they're not going to wreck the place and they're going to take good care of it because I want my money back. Because at that point, it's potentially my money. So I just throw those out there. That's just something for boards to consider in this whole process, and it is something for you to take a look at and see what you want to do. Other than that, I know we have. You mentioned a little bit about the new law, Peter, and I think what we'll probably want to do is somewhere down, maybe in the next couple months, after the dust is settled, maybe sometime in April or early May, maybe it'd be a good time to have you spend a show going through some of those legislative changes, and we'll let the listeners know. We'll set it up in advance and schedule it so that you can, that you can go through it, Peter, and talk about some of the changes that have been made and some of the things that people need to consider, both on the HOA and on the condo side. So we'll do that coming up. Let's see what else has come up this week or this in the last couple weeks that I wanted to bring to people's attention or talk about. I know we talked a little bit about the hurricane issue and accounting. I do want to mention that again. If you're an association that's had an issue with hurricane damage or potentially have an issue with hurricane damage, remember you need to, at least if you're having financial statements put together, you're disclosing it, and so make sure you're doing that. The other thing that I guess came up this last week is I got a call from another association asking about an audit, and they are going to have one done. They have been waiving it. They were normally required to, and they've been waiving their audit. They can, of course, as I mentioned to them, they can still waive it, and that law has been changed now. They can waive it as much as they want, but you don't waive it, you reduce it. And that's one of the things that I wanted to mention is many of you have what you thought was waived your financial statement requirement. You cannot waive it. You can only reduce it to the lowest level, which is a financial report. And keep in mind that the financial report, at least right now under the law, is not what your bookkeeper is giving to you or what your property manager is giving to you. They're handling your books on an accrual basis. They're doing it, and putting together a set of financials. It's much closer. What they're giving you is much closer to what you would see in your financial statements from your CPA, maybe even exactly the same. But it is not a financial report. So some people think, oh, okay, I'm doing the same thing I would do for my CPA, so this is okay. It just doesn't have an opinion letter on it. Nope, that doesn't qualify. That is not a financial report. So if you waived the CPA prepared report and you lowered it to a financial report, you need to look at the statute relative to financial report. That's a cash basis report. You need to look at that and need to put something together for them that is financial, that meets the requirements of that financial report, which, like I said, is a cash basis, pure cash receipts and cash disbursements. It also has requirements that certain expenditures be individually shown on the statement itself so that you can see what was spent on those expenditures, including things like insurance, things like security. All of those kind of things have to be broken out separately on the statement on a cash basis. Not so if at the end of the year you have scheduled to pay, let's say you got your bill for your insurance, and you've gone ahead and scheduled to pay that, and and gotten that ready to go, but you haven't paid it yet. Well, that's not an expense. That's not something that you show. So that year's statement might show that you have no insurance expense. Well, you still had insurance, but you may still show that you have no insurance expense because it hadn't been paid yet. So those are the kind of things you have to look at. You also have to provide a budget which shows some information to the people there. So keep that all in mind and take a look at that, and we'll talk a little bit more about that some other time. But I did want to mention that so everybody's aware of what the requirements are and what you need to do there. So, Peter, did you have anything else you want to mention? We got a couple minutes here. You want to mention anything and wrapping it up?
No. I mean, we can talk about the new laws, like you said, coming up.
Yeah.
There's, nothing I want to add in the last minute here.
Okay.
Really.
All right. Well, I think we had some good topics today, and we got some. Jim asked some good questions. We got to discuss some issues we haven't talked about for a while. I will mention, we're here every Monday from 9 to 10 to help you. So please give us a call if you have something. Tell your friends about the show, and we're going to be here off season and in season. So for some of you that have been busy, in season, and now as board members you're starting to look at some issues, go ahead and feel free to tell your friends, let them know. They can watch it up north. You can WSTU1450.com. That's WSTU1450.com. You can watch the show. It streams every week as well. So if you're out of the area and you're going to be back up north and you want to see what's going on, you can tune in, and you can, of course, call us still, and we'll take your call and answer your questions and anything that you want to talk about. We're here to help you. We've been doing this for some 16 years or so, and the idea is to give you some information that you can use. So thanks for joining us right here on WSTU Digital 1450. We are Martin County's Heritage Station.